Sadly, COVID-19 has taken the lives of over 90,000 Americans and over 300,000 people around the world. Such a tragedy, and the numbers are rising every single day. With all this going on, ladies-in-law want to help you and your family stay protected.
Yes, and we have even had a client that passed away during this pandemic, and not even from the COVID virus. He passed away from a heart condition he didn't know about, a heart attack at age 52, completely fit and healthy. And the problem was, just 3 months ago, he and I spoke about getting his estate documents together, a will to protect his family, and he didn't have that chance to do it. Hi everyone, thanks for tuning in.
Make sure you like our video and subscribe to the Ladies-in-Law.
Yeah, you know that little heart and thumbs up at the bottom of your screen? Click it before you do anything else.
Right, because legal news like this is too hot to miss, and we're bringing it to you every Thursday at 3 p.m. I'm Rippy.
And I'm Shake.
And we're the Ladies-in-Law.
Where we're ripping and shaking up all the legal information you know, need to know, and want to know.
From the tabloids to the courthouse to your own home.
For this episode, we're going to be going over a complete overview of the common types of estate planning documents and strategies. And all of them are important, so you want to wait to the very end so that you don't miss any of it. Well, I'm going to start with the most common and beneficial type of strategy you should implement with your assets in estate planning. And that is making sure that you include the specific beneficiaries that you want on specific assets even before you die, or even if it's in the will or whatever. So you've got like your life insurance policy, your house deed, your bank account, your retirement account. You want to put your beneficiary on those specific assets immediately. The importance of this is they skip probate then. If you pass away and I'm, for example, your beneficiary, well, it's automatically to your bank account. It's going to come straight to me. It doesn't have to go through probate. Don't have to deal with any of that. It saves such a headache. And it's so great. And you make sure you know that the person you want to have get it, gets it.
Right.
Now, there's a big thing with jointly owned things such as homes. Well, of course, if a husband and wife are both on the house deed, it's a jointly owned asset. If husband dies, well, you got to remember, his half is automatically going to go to his wife. There doesn't have to be a new deed issued. All that the wife has to do is go take that deed to the Register of Deeds and make sure everyone's put on notice that now she is the full owner because she automatically had that transfer.
That is correct. That is such a big benefit with these properties that you are able to add beneficiaries to, is that they automatically go to the beneficiary. So any property that you're able to designate, like the ones that Mina listed, retirement accounts, bank accounts, houses, any property that you can have beneficiaries or have jointly owned, it's a big benefit for you as well as your heirs to name someone that the property passes to. So we've talked about a strategy. Now let's get into the estate planning document. So the main estate planning document is a will, and I'm sure you all have heard of a will. Some people will say, oh, you know, I don't need a will because I'm just going to leave everything to my children in equal parts, which is halfway true. So you can still benefit by having a will. Now, there has to be someone to administer your property after you die, which in Michigan we call it a personal representative. I know in Ohio and some other states may call it an executor, but it's still the same person doing the same functions. So in your will, you can actually appoint a specific person to do this so that there's no fighting over who's going to be the executor. You can save your children time and money, possibly if they have to hire an attorney, by just going ahead and naming that personal representative or executor. In addition, that personal representative or executor without a will have to serve with an insurance bond. So they have to basically put money up so that it's an insurance policy that they have to buy based on the value of the estate. So if the estate is worth more money, they have to put more money up to even serve in that capacity. The will can bypass all of this and say that the personal representative can serve in that capacity without having to post any money, and the court will honor that.
It helps so much.
Without that, the court is most certainly going to make that person serve, because they want to make sure that this person isn't swindling money from the estate. So that's the whole purpose of being bonded and being insured. Now, another thing, even though you want to leave all your property to your children, if you don't have a will, it's going to each child equally. You're going to get equal portions. So if you want to exclude some children, or if you want to give separate percentages to children, you have to designate that in a will. So I just actually recently worked on a will for one of my friend's fathers, and in the will, he is leaving everything to his daughter, my friend. And in case she dies, there's a contingency where it goes to her son. Now, her son is only 4 years old, and she and the father are not together. They've never been married, and quite frankly, haven't been on good terms for a few years now. So the backup contingency in the will is, if my friend dies, all the property will go to her son, which could be a problem if he's under 18. Now, if he's over 18, fine. But if he's under 18, if my friend's not here, then his father is going to be the one who's his guardian and is going to be actually in control of all that money. So we certainly,
and he did not want.
We don't want this because, like I said, they're not on good terms. Her father doesn't like him. So in the will, we were able to set up a special trust where if the son is supposed to inherit my friend's son / the grandson is supposed to inherit anything if he's under 18, then it just goes into trust until he's 18 to protect his father from being able to receive that money essentially and do what he wants to do with it.
Right. And speaking about trust, that takes us to the next type of estate planning documents, and those are trusts. And there are two types, and there's those that are effective during the lifetime and effective those at death. So I'm going to start with the first one, and that's called a revocable living trust. Revocable living trust, as it sounds, it can be altered, completely gotten rid of by the person that created the trust while they're alive. Yeah, and a lot of times our clients really like this type of trust because it gives them that sense of control over it while they're still alive, and they can actually you can transfer property into the revocable living trust while the lifetime is happening, that then skips probates. Another thing, just like the beneficiaries, why not? Probate, if you don't know, is a pain in the butt. It is not an easy process.
No, I will say, if it's a pretty small estate, then you may not need to go through the hassle. But if you have a big business or a lot of properties that you want to transfer, then it would be beneficial to set up a revocable living trust and just transfer them directly into the trust while you're alive so that they can avoid the probate process.
Yeah, and a critical thing in all of this type of trust, the revocable living trust, is the property must be transferred during the person that created the trust lifetime for it to be effective. So can't forget that, and hopefully if you have an attorney working on it, they better not. Now, the second type of trust is called an irrevocable testamentary trust. And this is the type that doesn't go into effect until the person that created the trust dies.
So, for example, the one that I put in the will for my friend's father, that's a testamentary trust. And all testamentary trusts must be placed in a will.
They must be. And a lot of times we find that people like her friend's situation, or people that just know that even if their kids are over 18 years old, they're gonna not know how to handle and manage the assets that they inherit. So the person creating the trust wants to make sure okay, things are handled appropriately. And a lot of times we get individuals that come to us that have a child with special needs, and so they need a special needs trust, which falls under this type of trust. This is when the beneficiary, really, no matter their age, they just cannot manage the assets on their own and how they get it, and they need very specific special provisions to protect them throughout the process. So that's when a special needs trust would come in with the irrevocable testamentary trust.
Yeah, and the person doesn't even have to be special needs. If you feel like you have a child who, regardless of their age or their mental capacity, is not going to be managing the money properly, you definitely can keep that money in trust.
And a lot of people like to do that, But the downside is, once it's made, set in stone.
So we've talked about wills, we talked about trust. The next important estate planning document is a power of attorney. Now there are two types of powers of attorney: medical and financial. The medical power of attorney really deals with medical healthcare decisions. You can designate someone to actually pull the plug, you know.
Yeah.
And while the financial power of attorneys deal with business dealings and financial affairs. So typically what we see is that with the financial attorneys, the person will just grant whoever they're granting the power of attorney to, grant them everything that they can do with their own personal finances. However, you know, there's still that option to set limits into place if you feel like you need that. Now, these financial and medical power of attorneys can either be effective upon signing or upon the person not being able to manage their medical or financial affairs.
Like being found, a doctor signing off saying no, they're not competent or they're not able to with their health to do these things.
Right. So for the ones that are effective immediately, we find that typically husband and wife want to do that because they're already, you know, trust each other and are doing everything together. But for those who want to make a power of attorney to their child, to a sibling, or to another person, maybe a friend, those are typically effective upon a doctor finding that that person is incompetent, is unable to make their healthcare decisions or manage their own finances.
Yes, which seems very appealing, right? As a client, we have a lot of people that's like, yeah, I don't want somebody being able to manage those things for me unless I'm completely on the outs. But in practicality, I know when I had to do this with my father recently, it took several weeks to get the doctor to sign off, to get the evaluation, to do this. And at that point, bills were starting to stack up. Decisions weren't being made, and his health was falling into a crisis. And so, you know, there's that fine balance of saying, okay, do I want that situation to arise, or do I want to have more of that no, I seriously cannot make that decision. And so that's knowing your situation, knowing who's going to be your power of attorney, and all of that, balancing it.
And regardless of which you choose, whether you want it effective immediately or effective when you're found that you're incompetent to handle those affairs, we suggest you having both a medical and a financial power of attorneys to make sure that all your bases are covered.
Absolutely. So, okay, that was a lot of information across the board, an overview of estate planning, but there's a couple just main points that you need to remember to give you that initial information about it. 1, if you have assets that you can list the beneficiary immediately on so it can avoid probate and automatically go to them, do it.
Right.
2, a will. You might think everything's just going to go to your beneficiaries, your children, whatever. You might as well just get a will. There's no point in not doing it. 3, trust. We got 2 of them. Revocable living trust during the lifetime of the person creating the trust. Or an irrevocable testamentary trust. That's during when the person dies, that the trust was created by. And 4, powers of attorney. You've got your medical power of attorney and your business/financial power of attorney. We just find it silly if you don't get both of them done. If you're going to get one done, might as well get both. So those are the 4 points that you need to remember, and it's really important. It'll help you a lot now, especially with everything going on in the world right now.
And we just gave you guys a general overview, just for common knowledge, but each person has a specific situation, so this is not to be taken as, this is the end all be all.
No.
Just to kind of put you guys on notice and understand what types of things you may need, but it's certainly very beneficial to consult with an attorney regarding your specific situation so that we can tailor these documents specifically to you and what you need.
So thanks for watching, and make sure you like and subscribe so that you get the hottest legal news every week from the ladies in law.
That's another episode of Ladies in Law, not your average lawyers. Rip it up, shake it up, rip it up, shake it up, rip it